The reason I became academic is because of Willy Mutunga. As I have told my students before, when I first came here 30 plus years ago, he was a bouncing young professor in his jeans and t-shirts and preaching revolution and the redemption of Africa and the world. And I was so intoxicated by that I owe him to this day. However, increasingly, as two independent academics, jurists, comrades, and friends, we have drifted apart. He holds a view of the Constitution that I don't, but my respect for him has never diminished even an inch. Does this Constitution contain a theory of constitutional interpretation? No, not at all. What does it contain? When you go to an art museum and see what Picasso has painted or Vincent van Gogh, the mad artist, you attribute to the painting complicated things that never went through Van Gogh's mind at the time. He probably woke up, took a few whiskeys and splashed his brush on the canvas. When we wrote this Constitution, because it was my great privilege to be there, I need to contextualize something. We came from a tradition where we believed, and history supported, that the Constitution had been abused, both by the executive, by parliament, by the legislature, and by other organs. We wrote a constitution to stop abuse. Everything that Moi had done, we wrote a provision to stop somebody from doing it in the future. We were so obsessed with that this constitution now contains several provisions that are unenforceable. What are we trying to say here? 259, we are trying to say, in the history of Kenya, the judiciary has been interpreting the Constitution in such a positivistic manner that it has become pedantic and nitpicking. And there is a lot of literature around that, the Dugdales, and a very conservative. In some of my writing, I say these judges were not conservative. They were subversive. They were subversive of the Constitution. They said things the Constitution didn't say. At one point, the court said, ridiculous proposition, that the Constitution is unenforceable because the rules required to be made by the Constitution for procedure had not been made, and therefore the substantive rule could not be enforced. That is not a conservative philosophy of law, that is a subversive philosophy of law. So we wrote 259. But 259 doesn't tell us anything we already didn't know. That we shall interpret the Constitution to promote its purposes, values, and principles. That we already knew. That's what every judge should have been doing all along from 1963. To advance the rule of law. That's exactly what judges should be doing. Permit the development of the law. That's what they should be doing. Contribute to good governance. This is not a theory of constitutional interpretation. It is an intention by a legislative organ to provide what, in its opinion, is guidance that will prevent subversion. Now, let me tell you something else that is equally shocking. The Constitution is not only a legal document, and if you read every page to give you a legal outcome, then you have missed something. The Constitution is both a political charter and a legal document. A third of this is poetry. If you go to page 1, which I wrote myself, I think Wanjiku Kabira, my friend, will confirm. I wrote this, we the people of Kenya acknowledging, honoring, respecting, committing, recognizing, exercising. That is not law. That is poetry. It is a part of the Constitution about how do we feel about ourselves? How do we inspire ourselves into? So if you look for law in the preamble, there is no law. And there won't be any law. So, what then would be a theory of constitutional interpretation? It would be this, and now I'll sit down. If you listen to the dispute within the American Supreme Court, that is a dispute about a theory of interpretation. The originalists contend that the whole Constitution is to be interpreted by asking yourself one question. What did the founding fathers intend on the year they adopted the Constitution? That's a very contentious question. There are others who argue that the Constitution must be interpreted from a textual perspective. You stay with the text, the language of the text, and the language of the text will yield the meaning of what the Constitution means. That is a theory of constitutional interpretation. There are others who argue about the structure of the Constitution. How is it structured? Because if you study the structure, you will study a hierarchy of institution and of values and of rights. That's a theory of interpretation. You can agree with it or disagree with it. There are others who have an ethical argument about the outcomes and so on and so forth. So let me answer the first part of the question by saying, I do not see in this Constitution a theory of constitutional interpretation. I see some poetry about how judges should generally conduct themselves. First, I want to affirm that everything CJ says about approaches to constitutional interpretation, I would concede. I would concede that the Constitution must be interpreted holistically. If we ever didn't do that, then we were very negligent. Every statute should be interpreted holistically. Every statute should be interpreted to be purposeful, to give effect. If there is a Freedom of Information Act, you must interpret to give freedom to information. So I concede everything that CJ has said. But I want to come back to why do we need clarity? Why do we need clarity on how to interpret the Constitution? Why should we be very, very worried of woolliness? Why would we be worried if our judges were woolly? It is because a theory of interpretation should be logical. It should be logical. Even the lay person who hears this outcome of a case should say, that makes sense. It is logical. It is consistent. It is coherent. It is predictable. It is objective. This is what the very old teachers of law, now discredited, like Lon Fuller, were teaching 90 years ago. They were teaching the inner morality of law. Law must have an inner morality. It is that inner morality that allows fidelity to law. If there is no fidelity to law, a judge is a loose cannon. When he wakes up in the morning, he says, I want to advance the ends of democracy. Kenya is a backward, underdeveloped democracy. I, Mr. Justice Kamau Njoroge, I want to advance the frontiers of democracy, not his job, above his pay grade. The frontiers of democracy have been codified by the Constitution to be extended and defended by elected officials, whom the people periodically call back and say, we heard what you said in the House, you don't represent us. One of the most important arguments against an activist judiciary is because the judiciary is counter-majoritarian. Who elected them? With all due respect to my teacher, but we are now talking the theory. Who elected judges for them to decide? Parliament is full of idiots. And I, Mr. Kamau Njoroge, must protect the population of Kenya. So Parliament has said in very clear black letter law, no person shall be eligible to receive higher education loans if that person has not demonstrated A, B, C, D. Parliament is making policy choices that politicians ought to make. Now, we have a judiciary sometimes that says, Mr. Minister for Transport, you have said you have banned matatus that have more than that have less than 14 passengers. That's not good. Why don't we put it at 7? That judge is not interpreting law. He's not defending democracy. He is an outright loose cannon. He has no such power in law. Now, so for me, what scares me is that you can have a judiciary that is activist in both directions. During Moi's time, a subversive judiciary would say, the president is above the law. You cannot question a minister. And it would go on and on and on. That is very scary. But today, with the same set of progressive tools, you can have a judiciary that says it will make law, it will override parliament, it will override its own binding precedent. Let me give you an example, which may probably show you how dangerous this is. A week ago, the High Court in Kenya made what I thought was an amazing declaration. It stated that the penal code provisions on what some broadly are called anti-sodomy laws are not inconsistent with the Constitution. To my mind, I entertain no doubt whatsoever that that is not an interpretation of the law. It is a baggage of inarticulate premises. Either they come from religion or custom or culture or wherever, but they have nothing to do with the interpretation of the Constitution. Because this is what the binding Court of Appeal precedent on the matter says. The Court of Appeal stated that a physical inspection of a Kenyan to determine whether or not they had participated in an unnatural act was unconstitutional. That law is not changed. For the High Court then to say that there is sex against the order of nature which can be determined not to invade the privacy protected by the Constitution, in my view, that is precisely the sort of judicial activism in the opposite direction. So what do we need to do? We need a theory of interpretation that is pragmatic, that is consistent, that speaks to the canons of interpretation that we can critique because they are objective. Let me finish by saying, what worries me most about the Supreme Court today, and I have said that to the Supreme Court the number of times I have appeared there, the Supreme Court of Kenya does not recognize any other law other than the Constitution. Every question is answered by check article this. My own argument as an academic and a practitioner is this. The Constitution itself recognizes that it's not a land law statute. Is it a land law statute? Is it a family law statute? Is it a company law statute? Is it the statute controlling criminal procedure? Is it the statute controlling civil procedure? It is not. So it is not an answer when the question is raised, where is the locus? Locus is important. The court is not a marketplace. You cannot say everybody can approach the court. It is even irresponsible. There is the economics of justice. We must be able to go back to a statute that says, how does the law of Kenya recognize that you can approach the court? By petition, by plaint, by originating summons. The Constitution cannot rewrite that. You cannot then go and say, you know, the Constitution recognizes that I have a right to be admitted to the university. Okay, so what have you filed before the court? I have written to you, Mr. Judge, a letter complaining. If we go down that road, in my opinion, we will not grow the law itself, which is parasitic on the Constitution. I used to tell my students, time has not changed my position on that point. If we can think of 100% of the law of Kenya, the Constitution is 10%. The Constitution itself recognizes that 90% of the law will be in the Dog Act, the Cat Act, the Donkey Act, the Maize Act, the Bean Act, and a million other statutes. And if it wasn't there, this would not be enough to govern our country. So I summarize by saying, therefore, a theory of interpretation of the Constitution should be minimalist, not maximalist. It should be a minimalist, not a maximalist interpretation. It is one that confines the Constitution to giving life to provisions. Let me give my last example, which I gave last year, Mr. Moderator. There are many people who say you can read this statute, this Constitution, to support gay marriage. I say it is nonsense on stilts. There are those who say you can read this Constitution to outlaw the death penalty. More nonsense on stilts. That's not my original language. That's the language of Bentham, whom you will meet or have met. Why do I say that? Because the issue of gay marriage was debated by us. Wanjiru Kabera will confirm. It was before Bomas. We debated it, and we lost the motion. So we cannot have a constructive way of reading the Constitution to legalize gay marriage, it means we are being dishonest. I am a great exponent against the death penalty. I argued for us to remove the death penalty. Many people supported that view. We lost it hands down. We can't creatively now come and read a provision that we lost on the floor of the assembly that voted on the Constitution. When I was Attorney General, a case was filed challenging the mandatory application of the death penalty without a judicial process. I supported it completely, and it's the law of Kenya now. And all death penalties are being reviewed today. So I would say, therefore, that a minimalist theory of the interpretation will save this constitution for longer. A maximalist, that it provides for everything and anything, anywhere, by anybody, will kill it before it has started crawling. Yeah. Again, we go back to what should a theory of interpretation contain? In my book, it should be prudential. A judge is prudent. What is it you are curing with your order? Is the order likely to cause more harm than the harm that already exists? A court order that says the election is tomorrow and we have nullified every station in the country, and if the election is not held tomorrow, the Constitution contains no provisions for expanding time. Therefore, the effect of my order is to create a constitutional crisis of monumental proportions that will require a constitutional amendment to be effected, but the House that can effect an amendment has already been prorogued. To my mind, that is not a prudential judgment. Let me give you the example of a prudential judgment. Not so long after the new Constitution came into force, it was realized that the budget estimates had not been published in accordance with the provisions of the Constitution and in time. A person went to court and said, this entire budget process is illegal and unconstitutional. The consequence of that was going to paralyze the whole of government for the foreseeable future. A judge, a very, in my view, and I take no credit in having trained him, but clearly, on his argument, which is the prudential argument, was this: that is correct. That is what the Constitution requires. But this is for directions. It is to direct a process so that the process achieves openness, transparency, and so on. To reverse this process would cause greater harm to the Republic of Kenya and its people than not to do that. That is my kind of judge. A judge who then says, I am applying the law, I don't care about the consequences, it's for politicians to worry about the consequences. That judge is not a judge, is a politician.
Thank you, Professor Githu. And among other decisions that are also posed interpretational challenges was the presidential nominations and the presidential election of 2012. The date had to be subjected to a court process in terms of interpretation of when it should be held. The Constitution spoke of and speaks of to date the first Tuesday of August. We ended up having the election on the 4th of March. I now want to go to the audience, please, by show of hands. I'm going to give you the opportunity to ask one question and specific to either Professor Githu or Dr. Mutunga.
They can also make comments.
My question goes to Professor Githu Muigai. My name is Miyawa. And I want to challenge you on this. don't you think it's too dangerous and even preposterous to propound a theory, a minimalist theory of constitutional interpretation, particularly in the context of what we now call a transformative constitution? The reason why I make that argument is this, that minimalism, as opposed to maximalism, comes with the inherent dangers of being restrictive, being narrow, and does not take into account multivariated phenomena. And for that particular reason, and for that particular reason, to propose a minimalist theory that does not take into account different contexts comes with the baggage, what you call the baggage, or a dangerous flirtation with the non-indigenization of law, because our law has to be vernacularized to reflect context, to reflect different diversities, whether ethnic, political. So minimalism, and especially because the legal interpretation we rely on in this country is that of the received legal tradition. And the received legal tradition is very dangerous. If you read very keenly the work of Etienne Murenic, who proposes a transformative interpretation of the Constitution. Actually, he even calls it a post-liberal constitution, because liberalism has got its own inherent danger that we cannot go into today. So I want to challenge you that it's very dangerous to propose minimalism, because minimalism comes with restrictiveness and narrowness.
Thank you. Professor Githu.
Well, I must confess that most of the words you used, I did not understand. Having said that, I think both of us recognize that the Constitution must serve a purpose. For me, what my experience teaches me, and I could be wrong on this, and my students are always suggesting that I am wrong, but they don't articulate it because of our friendship. What is my appreciation of what the Constitution should do as a jurist? In my view, the Constitution should stabilize the political and social order. If it doesn't do that, it is of no consequence. It's a piece of paper which every 2 years we will write, we will throw it out, a new group will come, we will write a new one and throw it out. I teach my students that the 60 solid years of uninterrupted constitutional rule in Kenya is more important, in my view, than having a transformative constitution in the mold of the South African Constitution, where you have a piece of paper that has absolutely no relationship with the way the people live. Okay? So you have Mandela's transformative constitution, and what does it do? It masks racism, it masks xenophobia, it masks the largest inequalities among human beings anywhere in the world. So we either want fact or we want rhetoric. Either fact or rhetoric. For me as a jurist, I have made peace with incremental change that stabilizes politics, that stabilizes society, that stabilizes cultures, so that my grandchildren will still be walking around with this constitution with a few changes inserted there, as opposed to a maximalist that would have thrown out this constitution 5 times and brought 5 other groups to write it. What do I do when I am confronted, like one of my pet subjects? What do I do when I'm confronted by, say, polygamy? In Bomas, my mind was absolutely clear. If we wanted to abolish polygamy, we were going to lose the whole constitution. If for no other reason, because of Joseph Martin Shikuku, who would not countenance that. When I went to Sharia House as Attorney General and we were pushing the marriage bills and I was being pressurized by my good friends like Panjuro Kabera and Patricia Mbote, and I was saying to them, let us listen to the wisdom of the Luo nation. This is where we go mos. We are going to get there, but you will not change society by imposing it on it a social value that it has not accepted in the name of maximalist. I rest my case.
And to something else he raised there that I just want to follow up. He basically argued that the words minimalist and transformative is a contradiction, isn't it?
Yeah. Do I want to transform Kenya? Oh, in the fullness of time, I want Kenya to be transformed. How do I want Kenya when I am an old man of 120 years? How do I want to live it? I want to live it an independent country without social inequality, without oppression, the equality of genders, the ability of people to define their sexuality. I see a huge dream of what Kenya can be, but I'm old enough to know that if I want that yesterday, I'm a fool.
Let's take a second question from right here. Thank you. Your name and a very quick question or comment.
Thank you so much. I'm Oliver Irupe. Professor Githu, if there is no constitutional underpinning in our constitution, as you denied in your first statement, where do we bring the minimalist interpretation at this time to the constitutional making in Kenya, whether by the judiciary or any other body, including parliament?
Does the Constitution mandate a theory of interpretation? My answer is no. Does the Constitution, in very broad terms, express a desire as to how persons interpreting the Constitution should do that? Yes. Is it different from what we had ever used before? No. So if you were talking to an American lawyer and you asked him, what theory of the Constitution do you subscribe? There is a person who can tell you, I subscribed to the doctrinal argument. That's what I'm saying. That is a theory about interpretation. But if you say to him, I believe it should be purposeful, he will say to you, that is not a theory about interpretation. Yeah? That is an approach to interpretation that is inherent in the judicial making process in any event.
Thank you. Let's come to Professor.
Thank you very much. My question is, in August 2010, we were all very happy. We danced and we celebrated the birth of a new constitution. A new dawn is what we called it. We were celebrating an opportunity that us as Kenyans, we finally had a chance to develop homegrown jurisprudence. Jurisprudence that was African, that was Kenyan, and that we could actually own, and that was different from the colonial past. To what extent have we been successful 9 years down the line?
Thank you. Can I start with Prof. Githu on that one?
Well, I personally take great pride in this constitution. I think it's a good constitution. It has helped us to achieve things we hadn't achieved before. I think devolution is a fantastic idea. It's not working 100% the way we would want. My CJ is right to say a lot of money is being wasted, it's being whatever, no problem. But I think it has changed forever how people access resources, how people are governed. I think that's a very, very good thing. I think our rights culture has improved. We have swung from a situation where the executive held the predominant advantage on allocation of rights. Now we are in a state where I believe myself that many of the fundamental liberties provided here are accessed by many people, not by everybody. There is much more that can be done and should be done. And so to that extent, I'm proud of it. But a word of caution. I think that those of us in the business of law sometimes mislead the general public as to what law can do. And I like to say to my students, non-lawyers have more faith in law than lawyers do. It's just like medicine. Many doctors have less faith in medicine than we ordinarily as laymen do. And I can assure you that there are many doctors who walk to the bedside of a patient every morning, find him alive, and they are totally shocked. There is a limit to what law can do to transform societies, because societies are more complex than you can't decree. You can't decree to a society, please wake up, be democratic, walk away now, and never be totalitarian again. The culture of totalitarianism is a culture that is within the fabric of how societies are created. And I can ask you, like I ask my comparative constitutional law classes, why do you have a decolonizing constitution? The British used the same decolonizing constitution in all their colonies, from Jamaica to Barbados to India to Pakistan to Zambia to Kenya. Why do these constitutions create such different societies? Why is India the largest, most shambolic, most chaotic democracy in the world, but it still holds 9 days of elections? Next door, Pakistan, decolonized with the very same piece of paper, a military dictatorship that has no chance of ever changing to anything different. It is because the underlying culture that irrigates the Constitution is as important as the Constitution itself. And I don't want to mention some friendly countries around us in which we all know that the Constitution changes every year because there is a new imperative to keep the leader in office every year. Okay? And so, I hope, Dr. Nkatha, I have answered the question that this is a good constitution. We are making progress. That's why I'm a minimalist. Every day we take steps. Every year, every decade we take steps. Don't be too harsh on yourself. We cannot transform society without transforming the culture. Let me say this because it's one of my examples that I give my students. When we went to Kisii to discuss the future of the Constitution, we met groups and groups of people who said, FGM is not on the table. Have you understood? That is not on the table. And I used to like telling this, as I interacted with, that Jomo Kenyatta went to London in 1927 on behalf of the Young Kikuyu Association with 3 demands: the return of the Kikuyu land, the right of the Kikuyus to educate themselves and their children, number 3, the right to Kikuyu FGM, 100 years ago. So we must understand what is it law can change and what is it that law must work with the culture to change. Thank you.
I'm Mercy and a student of UOM. My question is based on interpretation. We've talked much about the law and language. My scope is in the perspective of the language in law. According to the Constitution, It's stipulated under Article 7, 6, 35, 164, 250, and the articles goes on and on, to which they have redirected that the interpretation of the Constitution in terms of the rules and laws stipulated can be in either English or Kiswahili. And it further promotes and states that the judicial officers and the states should encourage, develop, and promote linguistic rights in the perspective of Braille, sign languages, indigenous languages, and I suppose the local languages. To that, I may be corrected. So my question is, what are your views in terms of interpretation of the laws? The laws that we see here, people don't seem to come to an agreement about. How far can we develop them in terms of even publishing a Kiswahili constitution, katiba in actual sense? How far can we go to putting out there a constitution that is in sign language, in the Braille, all for the purposes of the national values articulated under Article 10, inclusiveness, transparency, and equity? Thank you.
I think that to provide a blank check for judges to make law is to undermine democracy in a very profound way. Judges have no business making law. What judges do, good judges do, what good judges should do is creatively use legal principle, legal doctrine, legal rules to provide solutions. Very quick example, which I always give my students. Today in Kenya, we have no law on surrogate motherhood, in vitro fertilization, or related problems. We have a sperm donor, we have an egg donor, we have a womb donor. If I was a judge in Milimani and the three were fighting, I would not throw the file and say, there is no law, go to parliament and do it. I would go to contract law, I would find a doctrine. I would go to tort, I would find a doctrine. I would go to the Bill of Rights, I would find all these strands and I would put them together by legal reasoning and I would give an answer. Am I making law? No. I am constructing from what law has already given me. So I've answered that one. The last one is, my good friend says, Mwalimu, if you say that a judge shouldn't give an order whose effect is to create a worse situation than he faced, I stand by that. A judge should not be different from a surgeon. A surgeon never operates a patient whom he's not making better. Yep. A judge should not issue a legal order that makes the situation he's addressing worse. That's a prudential guidance. Let me give you, and this is my last example. As a young lecturer in this faculty, for the first time in the history of the faculty, there was a young lady who was about to get a first-class degree. Her aggregate marks was 69%. Her aggregate marks. My external examiner was William Twining. He's professor of jurisprudence at Oxford, and his father was last governor of Tanzania. And I told William Twining, do you mind if we have a moment outside the classroom? And we went there, and I told him, let's look at this mark sheet again. And we found 2 marks in the mark sheet, and we added them, and the young lady became the first person to get a first-class honors degree. The purpose... No, the first lady. I want to finish by saying our vocation is a vocation to do good. The vocation of law is to use law to do good. Thank you very much indeed.
Just before you sit, but you can actually take a quick rest, the final question and comment will come from Professor Wanjiku Kabira.
Many cases like those, particularly in relation to gender. Think of each area, you move from 50 to 25, and those, yes. So how does the judiciary deal with judges that actually cannot find how to deal with gender-related issues.
Professor Githu, you did say that there are things in the Constitution that haunt you. Beautiful, but they haunt the country. And I want to ask you whether one of those things is the 1/3 gender concept, which up to now has failed to get implemented.
My view was then, as it is now, that we faced an existential threat to the Constitution at that time if we dissolved Parliament, the very Parliament that was to resolve the problem that existed. We would have created a situation. And again, it goes back to my own constitutional philosophy, which is that it is important to safeguard than to destroy. And I thought we would dodge that bullet, live another day, live to fight another day. I lived to fight another day. I left Sharia House without resolving the problem. I drafted 3 different bills, and they didn't succeed. I hear there is another effort to do it. I wish them all the best. Now, 2013, 2017 presidential election petitions, I was in both. I'm happy to say that Willy Mutunga's first decision was the correct one. It was, in my view, I expected some heckling from students, not from professors. And the reason for me was very, very straightforward. The procedure where you hear a case without taking evidence is a very special procedure, because then all the evidential questions that ordinarily should be addressed by the law of evidence are not. And earlier on we talked about the Supreme Court believing mostly that the Evidence Act is immaterial. The Evidence Act is fundamental to the probative value that you attach to what is alleged to be evidence. I believe the 2017 election petition, the first one, was made in vacuo. I thought it was wrong. Now, listen to this. This may help you now to understand my philosophy. I believe the second one that went to correct the first one was even more, the jurisprudence was more confused.
That was Professor Githu, who said that and held the Constitution and said that it contains a lot of clutter. It contains a lot of many necessities, unnecessary things.
I must say on the gender issue, when we first started agitating around it for effecting changes, we had a lot of traction. We lost the public somewhere along the way because a perception developed that those who were already in Parliament were not making a difference. I want to use the word perception because I don't share that view myself. We need to rethink how we get gender parity without the difficulties that we have now. And my solution is very simple if we came around to it. We now need to have constituencies with 2, however we create them, 2 members, 1 male, 1 female. We leave that problem behind us. Whether it's the Senate, we have 1 county, 1 male, 1 female. We leave that problem behind us. What was the last point about?
Whether it's too soon to change the Constitution.
I think it's never it's never too late to do the right thing, Martin Luther would have said. Well, if we all believe that there is a problem, I think the sooner we address it, the better. Last point, I promise you, Linus, this is my last one. In the design of the Constitution, again, we misled ourselves in believing that if you had a president elected by 50+1, that would resolve completely and totally the issue of legitimacy. We were wrong. We were wrong. And if I were to do it all over again, I would try to create a broader base for national leadership so that there is a bigger inclusivity provided by the Constitution itself. I would even go the Latin American way, put people in the Senate as senators, allow them all that sort of thing. Because what we now have is a situation where dominant political actors are shut out on the day after the election. And that creates political turbulence within the system that is unnecessary. There must be a way of inclusivity. I don't know how.
Thank you. Thank you very much. Attorney General Emeritus Professor Githu Muigai,